Let's go ahead and get started. It's 9 o'clock, and I'll call the meeting to order. And Ms. Mahon, would you do a roll call?
Mike Mendez is absent today. Tom Butler.
Here.
Luann Morgan.
Here.
Fred Moses.
Here.
Catherine Rogwald.
Here.
Robbie Shaw.
I'm here.
Deborah Yurko.
Here. And I'm asking Commissioner Moses if he would open our meeting with a prayer.
Okay. Well, let's pray. Heavenly Father, we thank you for this day, Lord. We thank you for this hour. We thank you for the work we do as a commission. Continue to be with us and lead, direct, and guide us, that all the decisions we make that glorify and honor you. Be with us, Lord. As we serve others, we serve you. In Jesus' name we pray. Amen.
I need to back up. I need to have a motion to excuse Commissioner
So moved.
or
as
Chairman
recommended.
Arizmenda's absence.
So moved, as recommended.
Second.
Okay. All in favor, say aye.
Aye.
Okay, moving to item D, we're going to go ahead and break for executive session. Item 1, consultation with staff attorney pursuant to section 551.0711 government code, wherein the commission will receive a briefing from general counsel concerning pending or contemplated litigation and or settlement offers. On item 2, advice from general counsel on legal matters authorized by 551.0712. And that's the only 2 items that we'll be discussing. So we're going to break for executive session, and we'll be back probably in 20 minutes. So we'll reconvene at 9:25, let's say.
Okay. Just remember my first official act as director. I haven't figured out what it could be yet. Complete. We get the rule by executive.
It's 9:35, and we're going to reconvene and from executive session, and there's no action to be taken on the executive session items. So moving to item F, I would like to ask for approval of the minutes after the commission has a minute to look over the minutes. I'll entertain a motion for the minutes.
Motion to adopt the minutes as submitted.
Second.
Okay, all in favor, say aye.
Aye.
If anyone's here to testify on any of the contested cases or even for a motion for rehearing, if you haven't already, if you would, fill out a form there on the blue table and hand it to Ms. Mahon so you can testify. I'd ask you to do that at this time. And moving to item G, we're going to the contested cases, consideration and possible action for contested cases. Commissioners, on item number 1 for Christian Torres, we have a message here that he's asking to reschedule the hearing for today, that he's not able to be here. He says he didn't receive the notice until a couple of days, and he even attached a copy of the tracking process that he received the notice late. So if it's okay with commissioners, do you have a problem with rescheduling him to maybe the next meeting?
We need a motion for that?
Yeah.
The only question I have is it says that he received it December 21st, and he wrote the note to the commission on January the 5th. So that's like 15 days.
Yeah, it could have been a problem, I guess, from,
I mean, maybe it was delivered and he wasn't put in his hands, but it says it was delivered on the 21st.
But I don't think we've usually argued for one time.
Okay.
You're right.
Things might have changed.
Okay.
Do we have to have a motion
I
to,
move
yeah, and I'll second it.
Yeah.
okay, we have a motion and a second. All in favor, say aye.
Aye.
Okay, so
Okay, all right.
move to item 2. Is Thomas Tillman here? Okay, Mr. Sharp. Thomas Tillman. Let's see. Would you like to go
Morning.
ahead?
Morning, Commissioners. My name is Ken Sharp. I'm with the Enforcement Division. The respondent in this case is Mr. Thomas A. Tillman, Jr. The department issued a Class A barber license to Mr. Tillman on August 14th of 2012. He applied for renewal on August 14th of 2014. In 2001, the applicant was placed on community supervision for 4 years after he pled guilty to felony credit card abuse. In that case, the respondent used a MasterCard belonging to another person, but without that person's consent. Even though the respondent pled guilty, the respondent testified at the hearing that he had gone shopping with a woman and that it was she who used the credit card, not him. Mr. Tillman said he simply carried the bags that contained the woman's purchases and knew nothing of the credit card or her unlawful use of it. Mr. Tillman said he pled guilty because his lawyer told him since he carried the bags, it did not matter whether he knew about the card and that he was just as guilty as the woman. That, however, is not the law. Credit card abuse requires the offender to use the card, knowing that the card was not his and that he was not entitled to use it. And that's what the respondent pled guilty to. Also on the same date, Mr. Tillman was placed on community supervision for 4 years for the offense of theft of property with a value between $1,500 and $20,000. The respondent had stolen a computer belonging to the same person who owned the credit card he unlawfully used. Mr. Tillman offered no explanation for the theft offense. In 2005, the court revoked the respondent's community supervision, found him guilty of both charges, and sentenced him to 180 days of confinement in state jail. In 2012, 7 years later, Mr. Tillman applied for a Class A barber license. Now, at that time, it seemed as though Mr. Tillman had put his criminal past behind him, so the department issued him the license. However, while he was licensed, in January and May of 2013, the respondent committed 2 separate offenses of tampering with a government record. He was convicted and sentenced to 3 years in prison for each, but the court suspended those sentences and placed the respondent on community supervision for 3 years. Those 2 cases arose from respondent's fraudulent entries on Texas vehicle inspection reports. In May of 2014, the respondent also pled guilty to aggravated assault with a deadly weapon and was placed on deferred adjudication community supervision for 6 years. The respondent pled guilty to intentionally and knowingly threatening a person by using and exhibiting a firearm. Mr. Tillman testified that his father-in-law had come to his house and began shooting at him. After his father-in-law had shot all his bullets, Mr. Tillman then took his wife's handgun, which he just happened to have in his pocket, and started shooting at his father-in-law. The respondent claimed it was self-defense, even though his father-in-law was now essentially unarmed because he had no more bullets. The casual manner in which Mr. Tillman testified suggested he did not consider this was a serious incident. And also in May of 2014, the respondent pled guilty to the felony offense of aggravated assault of a family member and was placed on community supervision for 6 years. Mr. Tillman offered no explanation for that offense. Mr. Tillman committed his first offenses when he was about 23 years old. He went to prison when he was in 2005, and then he was released that same year. He committed the most recent offenses when he was about 34 years old, again, while he was licensed as a barber. He's currently on community supervision, and that's scheduled to end on May 27th of 2020. The Commission's guidelines for licensed applicants with criminal convictions lists crimes against the person, such as assault, as crimes directly related to the occupation of a barber. And the Commission may treat these deferred adjudications for assault offenses as convictions if the Commission determines the respondent may pose a continued threat to public safety, or employment of the respondent as a barber would create a situation in which the respondent has an opportunity to repeat the offenses of aggravated assault or aggravated assault with a deadly weapon. The administrative law judge erroneously limited the analysis to events that occur in the workplace or in public and concluded the respondent's deferred adjudications should not be treated as convictions. The ALJ wrote that since the shooting occurred in the respondent's home and not at his barber shop or in public, the respondent posed no risk to the public, and employment of the respondent as a barber would not create a situation in which the respondent would have an opportunity to commit aggravated assault or aggravated assault with a deadly weapon. Well, the ALJ's conclusions were not correct because neither the statutes nor the Commission's guidelines distinguish between crimes committed in the workplace or in the respondent's home. The proposal for decision written by the ALJ is also incorrect because, first, the respondent's conduct in his home did create a risk to the public because there is a very real danger that stray bullets can go through walls, windows, and doors and not be confined to just the respondent's residence. His propensity to shoot at another person, even inside a building, may pose a continued threat to public safety. Second, barbers are personal service providers. It is not uncommon for personal service providers to encounter dissatisfied customers who become angry, belligerent, or hostile. Now, if Mr. Tillman would commit dangerous, violent acts against a family member and a relative of a family member, individuals whom the respondent presumably cares about, it stands to reason that he would commit acts of violence with even less compunction against persons who are not related to him, such as belligerent, angry, or hostile customers. Consequently, the continued employment of the respondent as a barber would create a situation in which the respondent would have an opportunity to repeat the offenses of aggravated assault and aggravated assault with a deadly weapon. You should reject the ALJ's limited analysis and erroneous conclusion and treat the deferred adjudications on the assault offenses as convictions. And furthermore, the respondent was convicted of 2 separate offenses of falsifying Texas vehicle inspection reports, which are government records. The falsification of records, which he committed in 2013, was with the intent to defraud and harm another, and it reveals a lack of trustworthiness, honesty, and integrity. It also shows the department's trust in him was misplaced when the department licensed him less than a year before that, in 2012. The respondent offered no evidence of any rehabilitative efforts. He committed the aggravated assaults on December 1, 2013, and applied for license renewal 8 months later on August 5, 2014. It was 8 years between the respondent's credit card abuse and theft offenses and the 4 most recent crimes. So 8 months is an insufficient period of time for the department to confidently determine the respondent, as a barber, will not pose a threat to the public or even exercise his abilities to falsify documents to his advantage. Despite the facts and circumstances of this case and the absence of any evidence of rehabilitation, the ALJ concluded Mr. Tillman had demonstrated sufficient honesty, integrity, and trustworthiness to hold a barber's license and concluded he was fit for a provisional license. Well, the department recommends that you reject the PFD and issue conclusions of law stating, first, the respondent's deferred adjudications should be treated as convictions. Second, the respondent has not demonstrated he has the required honesty, trustworthiness, and integrity to hold a license. And third, the respondent is not fit to hold a license at this time. The department recommends that you deny Mr. Tillman's application for renewal and revoke his Class A barber license. Thank you.
Commissioners? Questions for Mr. Sharp? Questions?
Is Mr. Tillman here? No, you said.
Yeah, is Mr. Tillman here? I asked a while ago, but I didn't hear a response of cover sheet.
I'd like to make a motion. I'd like to make a motion that we reject the PFD as recommended by the ALJ because of Mr. Tillman's trustworthiness, and that we changed finding of fact number 16, where it states that he has demonstrated honesty, integrity, and trustworthiness to support the issuance of a license, and deny him a license.
Change conclusions of law too?
Number 16.
And conclusions of law 12 and 13.
Mr. Chairman, this is Brad Bowman, General Counsel. If I may make a couple of suggestions there. One is also conclusions of law 12 and 13, I think, would be, if you're accepting the prosecutor's arguments and recommendation, those would
Okay.
need to be changed as well.
Let me modify my motion then to include changing conclusions of law number 12 and 13.
Do I hear a second?
Second.
Any discussion?
I guess it would be to Mr. Sharp. Am I understanding correctly from what you said earlier that just the mere fact of being charged with credit card abuse and tampering with evidence, that all lends itself towards the lack of trustworthiness of this this person, Mr. Tillman?
Cumulatively, yes. The credit card abuse, the theft, the 2 counts of tampering with a government record, falsifying those documents, especially since the 2 counts of falsifying the government records, tampering with the government documents, occurred while he was licensed. In fact, less than a year after he became licensed.
And when was his last conviction?
His last conviction would have been in 2014, and that was for the tampering for the government records. On May the 28th, he went to court on both those 2 counts and on the aggravated assault with a deadly weapon and aggravated assault against a family member.
Which is extremely recent to this motion, correct?
Yes, Commissioner.
That's all I have.
I had a couple of questions, maybe this is not directly to you, Counsel, but to maybe staff. In issuing a provisional license, what are some of the impacts on staff? I mean, I know this is not something that we do on a daily basis, but what would be some of the impacts?
Well, we're not really set up to monitor someone's daily activities. When you have the provisional license, you have the requirements of reporting the activity, where did you work, report the type of work you did, the place that you did the work at, and we're just not really equipped to do that. Our philosophy and Bill's philosophy has always been, if we're going to let them work, give them the full license, give them the ability to go everywhere and do what they're going to do. And having those mechanisms that you kind of envision with the probation officer, going to visit with them monthly and weekly, we're just not equipped and set up to have that level of monitoring.
Basically, what you're saying is, and if I can just paraphrase, we're a licensing and regulation agency. We're not a probationary agency where we're monitoring the activities of an individual during a probationary license.
Absolutely. When you look at some of the provisions in Chapter 53, it kind of harkens to having that probation type of feel to it. And again, we're not set up to do that.
Also, Brian, when the legislature passed the statutes to start licensing, they didn't make a distinction that there should be a residential license and a commercial license. It's just a license, correct?
That's correct, particularly in this case here. The legislature has always been very specific in identifying when a license is limited in scope. Residential appliance is limited to that particular activity, but when you have an electrician license, it is wide open, and it does not, bifurcate or separate the work that can be done.
We have a motion and a second. Any further discussion? Okay, all in favor, say aye.
Aye.
Aye. Any opposed? Motion passes. Moving to item 3. Philip Wiley. Is Mr. Wiley here? Would you fill out okay, would you fill out part of this, please? Okay, Mr. Sharp, I'll let you get started while he goes ahead and fills out.
Thank you. Well, there are two things that I should address. And first, I'll address the fact that Mr. Wiley appears here without counsel. Yesterday afternoon, we learned that his attorney was sick and would not be able to be here today. We discussed how to proceed, and I think as we get into it, we might be able to determine better whether he needs a continuance or whether we can resolve this matter this morning. The second thing that I should point out is this is somewhat awkward in light of Deputy Director Francis's recent comments on the last case.
That's all right.
Because, but I'm used to feeling awkward, so
That's all right.
I'll muddle through it.
I specialize in awkward. It's okay.
I do, so. Anyway, our case here, of course, involves Mr. Philip M. Wiley, and the department initiated action to revoke his journeyman electrician's license based on his criminal history. Now, the ALJ recommended suspending his license for 1 year and then reinstating it, but allowing Mr. Wiley to work on only commercial or industrial job sites and under the continuous supervision of his employer. This case came before the Commission back on September the 9th of 2015, and the department recommended revocation of Mr. Wiley's license. Mr. Wiley, on the other hand, and his counsel, who was here at that time, urged the Commission to reject the PFD and to allow Mr. Wiley to remain completely licensed. Now, since it's been a while, I'll be glad to go over the facts again if you want me to. I don't know if you've had an opportunity to review those or if you remember them, because there was quite a discussion during this case at that time back in September, and it was pushed forward to allow the parties to work on some things. But I'll be glad to go over the facts again if you want me to.
Would you like to hear the facts again?
I don't think so.
Everyone okay?
Yep.
Okay. Then, like I said, it was back in September when the Commission debated this case fairly extensively, with some of the commissioners apparently favoring revocation, but not a generic probated revocation, because if the respondent did commit any violations during the probationary period, the department would have no way of discovering it or doing anything about it until the next renewal process, and then it would proceed the same as if there had been no probated revocation. Other commissioners, you may recall, seem to lean towards some type of supervised and restricted licensure, possibly with the requirement of having the respondent's employer present at the meeting to verify the employer's ability to comply with any monitoring requirements imposed by the Commission. After reaching no resolution, the Commission passed the case to a future date and suggested that in the meantime, the parties should see if they could work something out, some type of resolution. And we did work on that. Since that time, the Department and counsel for Mr. Wiley negotiated and reached an agreement on terms that would serve as a suitable basis for the disposition of this case if the Commissioners find those terms acceptable. Now, General Counsel, of course, can advise you of your options, but I believe the Commission could adopt these terms in a Commission's order, in the Commission's own order if the Commission wanted to. Alternatively, if the Commission finds the terms acceptable, I believe the Commission could remand the matter back to the Department for disposition in accordance with those terms pursuant to an agreed order. In fact, Bill mentioned a possibility of an agreed order back in September the 9th. But again, I would defer to General Counsel to provide guidance in that regard. And although I think you might have a copy of those terms in your meeting materials or maybe a summary, I can summarize the most significant points if the Commission would prefer that, and of course that's where it gets awkward.
Why don't we do that? Most of them, yeah, why don't you do that?
Okay.
Okay. Of course.
Well, first, Mr. Wiley's journeyman electrician license would be revoked, but that revocation would be probated for 2 years to allow Mr. Wiley to continue working as long as he complies with the terms of the order. Those include that he may only work at commercial and industrial projects and may not work on or be present at any occupied residential job sites or at any school or other facility where children under the age of 18 years are present. Mr. Wiley must provide the Department with initial and periodic written verification signed by his employer that Mr. Wiley's terms of employment comply with those just stated. He has to notify the Department of any change in his job location or duties, or if his employment changes. He'll be required to accept and respond to all communications and information requests from the Department. He'll be responsible for the accuracy and truthfulness of any information submitted to the Department by him or on his behalf. He's to comply with all laws and must not commit any criminal offense. If he is arrested, he has to report the details to the Department. And this is seems like kind of an extension of maybe what might seem prudent. But the reason for that is because if Mr. Wiley were arrested and then convicted and then sentenced to jail, he might not have an opportunity to report to the Department that he had been sentenced to jail or that he'd been convicted and sentenced to jail. So by notifying the Department that he's been arrested, it allows the Department to then be on alert that there may be something in the works there and that we may need to monitor that case a little bit more closely. So that's the reason for that particular term. Also, if Mr. Wiley is convicted of or placed on deferred adjudication for any criminal offense other than a minor traffic violation or Class C misdemeanor, there are limitations on that. Or if his probation or community supervision is revoked, he must notify the Department that at that time and the license revocation would be imposed. Now that's a nutshell version, and of course there are a lot of operative details, and the Department and Mr. Wiley's attorney have worked hard to make sure that everything would work in a reasonable manner to protect the public and then still allow Mr. Wiley to continue to work. And I would like to add, especially in light of Brian's comments, that, and some of you may have already been wondering about that too, but this is not something the Enforcement Division has the resources to do on a regular basis. I'm not even sure if we have the resources to do it now, but we're going to try it. It requires considerable monitoring by the Department of the reports and verifications that Mr. Wiley is required to submit. And we've never done this before. But for the purpose of this case, both parties agree that these terms seem like a suitable disposition, and we in the Enforcement Division are willing to give it a try and see how it works. Are there any questions on that?
Commissioners, any questions for Mr. Sharp? Seeing that there's none. Let's see, Mr. Wiley, do you have a question?
I guess between Mr. Wiley's attorney and yourself, you walk through these conditions that he would do, and it would, for the most part, if something unusual happens, then if an unusual event happens, then Mr. Wiley would contact you. Would report in.
Yes, sir.
Exactly.
Yes, sir.
That's the essence of these conditions.
That's right.
The 20 you have, exactly. And you feel that this is reasonable considering you haven't done it before, but you've worked through this and you think that it's a reasonable plan.
We worked through it quite a bit, and,
Yes.
and that's true, we are plowing new ground here, but,
Okay.
and we may not grow a crop
Well,
either. But,
okay. Well,
but we're willing to give it a try
Well,
and
willing to give it a
see what
try.
happens.
Okay, very good. Okay, all right, very good.
Mr. Wiley, did you fill out a public comment form? Green, please.
I have a question, and it probably needs to go to Brad. I agree with Mr. Sharp that if we are going to go in one direction on this vote, we should probably continue this so his attorney can be present. But I don't know how we do that without taking a straw vote or whatever, where we are, to even see if it's necessary.
This is Brad Bowman, General Counsel. I think you could have some discussion that might reflect that. And I do agree that since the respondent is here without counsel, if the commission were not going to accept this agreement or wanted to do something else, like revoke the license, then I would recommend that you consider continuing it so the respondent's counsel can be here.
Commissioner, may I add
But-
something to that? That was part of the agreement, that if the commission wanted to do anything other than either accept this in the commission's own order or refer it back for an agreed order on these terms, then we would agree that a continuance would be
Okay.
appropriate for Ms. Sullivan to be here.
And as, this is Brad Bowman again, as Ken mentioned earlier, my recommendation would be if you accept the terms of the settlement to dismiss the PFD and refer it back to the department to go through the regular agreed order process.
I personally, as a discussion point, as Brad was suggesting, this conviction is not even a year old from when this motion was filed. And it does have issues with public safety, and this is a license that would allow this person to go into private homes. And I personally would rather see this move and continue so he can have legal counsel present.
I'd like to add to that if I could, in answering no on the renewal application just 6 days afterwards, I think harkens many questions in my mind as well. So,
Okay, yeah, my feelings is that, really if, I think, as we send in this back, and we had a lot of discussion on this when we met in September, and since Mr. Sharp and their counsel have worked through these terms, I'm more of the opinion of that, to go forth with the terms that as already worked out. I'm in favor of trying this process of accepting what has been worked out.
may I ask a few questions, since Mr. Moses brought that up? How would we monitor Mr. Wiley?
The system we have proposed, at least to monitor this, is that Mr. Wiley submits written verification from his employer. Now, the burden is on Mr. Wiley on this because,
Yeah, it really is.
because the commission, of course, doesn't have any jurisdiction over the employer. But Mr. Wiley is responsible for submitting written verification from his employer that he's in compliance with the terms of the order, whether it be an agreed order or commission order. He also has to do that initially and quarterly. And there are time limits within which those verifications must be submitted to the department, received by the department. He also, or rather, these things would come to my legal assistant, who would be monitoring this. And as I indicated, our resources are limited, but I think we can, at least for the purpose of this one case, to try and see how it happens or see how it works, we could do it. But putting that aside, those are essentially the monitoring mechanisms.
On the written verification, would it be notarized, or how would you know for certain that that verification from his employer would be authentic?
We would be willing to accept just a written verification on the employer's letterhead signed by I think the president of Rose Electric is the person who's going to be signing those, and who's, as I understand it, Mr. Wiley already has the first one, just in case the terms are approved.
Well, here are my thoughts. First and foremost, I think you're setting a precedence in here, and if you're setting a precedence, then we need to look at this new ground that we're treading in. I asked the earlier question on the earlier case, what is our role when it comes to provisional licenses? And then you heard from Mr. Francis exactly that we are in the business of issuing licenses as a regulatory body. Our role is not to monitor what individuals are doing and then, keep them on some sort of a probationary, periods. I think the commission needs to decide in which direction they want to go in when it comes to these types of cases, as we'll see future cases come forth in the future agendas. And if we set a precedence with this case, then I would like for us to come back and visit some of the other cases that we have so denied, because you are definitely setting a precedence in here. Issuing an agreed order and having to monitor that agreed order, I think sets an undue burden. This may be one case today, but there may be future cases. And I can imagine in the next 5 years how many more cases that our enforcement agency would have to burden. So from my standpoint, I think I would not be against that.
I understand. And this grew from the concept that probated revocations have been imposed in the past by the commission. But the problem with those is the probated revocation is essentially no revocation at all. It's essentially just complete licensure for practical purposes because there's no way to monitor it. And our thinking here was that if we're going to have a probated revocation, as we've had, as the commission has done in the past, then we might as well have a probated revocation with some mechanism to enforce that probation and impose the revocation if the terms of that probated revocation are violated. And that's where that came from. I'll be honest with you, I don't really favor this much, but given the atmosphere of the commission's debate the last time we were here and the concept of the probated revocations that have been imposed in the past, this is kind of an attempt to bring all of that together and at least make those probated revocations meaningful in some way, rather than just simply, as a practical matter, either issuing the license or not issuing the license. The probated revocation qualification really adds nothing to it without any kind of terms or any kind of enforcement.
And I agree with you, and if I can continue, Madam Chair. I think moving forward, I think what I would recommend, and this may be through staff, this may be a work session item that we need to go back and look at very closely. And in the previous case that we just so denied, I think maybe that may be a case that we may want to come back and visit as well, based on whatever we decide at some future date. I just feel like setting a precedence for this particular case, what would stop us as a commission in looking at another case that comes up at another agenda item and asking staff to put together an agreed order? And then where does that stop?
Go
sorry.
ahead. Go ahead.
Well, that's a point well taken, and it's certainly a valid concern of ours as well. I think the reason that we were a little more willing to do it in this case is because of the significant efforts that Mr. Wiley made toward rehabilitation once he was released from incarceration. Notwithstanding the fact that 6 days after he was released from jail, he falsified his application.
One more question.
Yes, sir.
Would you be willing to do that at a future case if I asked you to do that? And would staff agree then for the next 20 cases that come?
Well, I think what the problem is, what we have is, when we have cases come before us, we take each case on its merits. And now we can't say that. We can't predict what's going to happen after today, after this case. I think we take each case based on the merits, based on the facts that are presented to us, and that's what we're here to. That's what we're here to do.
I'm following what Fred said. There would be some guidelines that we would have to determine folks falling into that category of probation. But it does harken to mind, Mr. Wiley, this isn't your case particular, so, but we're talking about the bigger construct of a probation license. Mr. Torres's case, two cases back, there was a shooting involved. When we start monitoring these licensees, are we going to be going out in the field? And are we opening up our employees to the possibility of getting shot? This man had a gun and he had a shootout with his father-in-law. Where do we draw these lines? We're not set up to do this. Are we now going to become a law enforcement agency within the TDLR? And where are the repercussions for Mr. Rose Electric and Mr. Wiley's case? if this man just submits paperwork because he's making money off Mr. Wiley, is there incentive for him to skirt a little bit of the law, or to say he's not doing residential work? If we have to go out and actually monitor it, do we have a mechanism to arrest him for failing to be honest? I mean, these are things that you have to take into consideration. If it's a drug offense, are we going to start doing urine analysis in the field? Are we going to be able to call him in and say, we need a urine analysis because we put you on probation because you had a drug case? We haven't even begun to explore the ramifications of this. Are we going to do cocaine testing? Are we going to go THC testing? What exactly are we going to do? Are we going to install breathalyzers in vehicles because he was an alcoholic and did something to violate his license with alcohol? This calls for much bigger questions than we're really discussing here. We're just talking about probating a license. But when you start talking about monitoring probationers, we don't even know what we don't even know.
But I think, well, the other part about this monitoring, we're asking the licensees to do reporting, and that's what we're doing. We're not saying, I don't think we're asking Ken and his counsel and enforcement people to go out, but we're saying, in this case, we're asking them to report on his activities. That's what we're asking in this agreement, and so that's, I think when we think about envision what could happen in terms of us doing it. We're asking this licensee to say, these are, if you have activities, this is what you need to do, right? That's basically what the agreement says.
Yes, sir.
We ask it, and the onus is on him.
You make a good point, Fred, and I'm just talking about, we got here on a slippery slope, and where does it end, is all I'm saying. This is Mr. Wiley today, and next month we're going to say, well, we let Mr. Wiley have it, and this guy's only done one more thing. And I'm not saying we don't. I'm just saying this is a big discussion, and let's not do this piecemeal. Let's establish what we want to do and how we want to do it before we start doing it.
But if I'm remembering correctly, we instructed them to go do this. So we would now they did what we said, and now we're revisiting it and reversing ourselves?
I don't think so.
Because we instructed them to go do it, and they did what we asked them to do.
But that doesn't mean that because we have some concerns based upon what they came back with, that we now have other questions. Life is messy, and this is a messy question.
Commissioners, I think this is a good discussion. I'll bring you back to one thing, too, that Mr. Sharp said, though. In the past, we have issued probate and revocation of license, and there's not been teeth in it. And I think, back in September, that was a discussion, we were discussing, making a probate and revocation of his license, and so we were trying to look at how we could do it, so, and put some teeth into it. So, because really when we do a probate and revocation, there's really no teeth in monitoring it when we do issue that. And so how can we, when we do issue a probate and revocation, how do we put some teeth into it? So, in the long term, I think this may be something worth looking into. Commissioner Yurko.
Yeah, actually, I think the reason why in some of those cases we've done it is because it's an annual 1 year, and they're
Right.
gonna just reevaluate it. That's where the teeth is.
Right.
Right. They don't have to monitor it on a monthly or weekly basis. They're gonna get it they're gonna give them a 1 year chance.
Mm-hmm.
And that's where I think the teeth are. What they're asking us to do now is become a Department of Licensing,
Monitoring.
Regulation, and Monitoring.
Yeah.
As opposed to just a TDLR.
Madam Chair, Brian Prince, if I could just add a few things, and I know that the conversation is exciting, and people are on the edge of their seats. You can see they're trying to figure out where it's going to go. This definitely requires more discussion.
I think
just
so,
to
too.
think through it, because
Yeah.
there are other ramifications. Commissioner Roadwall is right. The staff and Mr. Wiley's attorney there was a lot of
Did what
discussion
we
from
asked them,
the
yeah.
dais, and even Bill was saying, go figure it out and come back with a plan and a proposal. but I think it was a proposal, not a definitive, you have to do it. I think it's appropriate to have Mr. Wiley's attorney here at another occasion. I will say that the things that I'm hearing, the teeth in the prior scenarios was also in, if there was a penalty attached, their failure to pay the penalty gave us an opportunity to say that they violated the order. Now we can take them up on violating the order. So that was part of the teeth. But the thing that we're missing, I think, in this conversation is that when we do set a precedent, and we always will, you make tough decisions, it's the attorneys that are listening for the next case that are going to come to the next hearing with that proposal. It's not necessarily you're going to be debating it. You're going to have attorneys coming to you saying, we want the same deal that the person got 2.5 months ago. And that's something I just want you to be mindful of. We got smart people in the room sitting on this side and throughout the agency. We can figure out some ways to get some comfort. I don't know if this is the perfect shot of a scenario that we've laid out there.
Can I make a motion based on some of the discussions we've
Yeah.
had so far?
Yeah, because I think we've kind of gotten off this case and
Yeah.
and way off
Right.
base here, and we need to get back on track. And-
Okay.
And Mr. Wiley, if you're okay with having your attorney here,
I haven't made a note
Commissioner Yurko would like to make a motion.
And I would like to make it, because I do feel uncomfortable that he is not represented with an attorney who's not feeling well today. So I would make a motion to continue this to the next meeting.
I'll second that.
Okay, any further discussion? All in favor, say aye.
Aye.
Any opposed?
No.
Okay, we have a 4-2. And would you like to do a roll call on that, Ms. Mahon?
Tom Butler,
Aye.
Luann Morgan,
Aye.
Fred Moses,
No.
Catherine Rowell,
No.
Ronnie Shaw,
Aye.
Deborah Yurko.
Aye.
42? Okay, so the motion passes 42. Okay, moving to item G4, Jeffrey Patterson. Thank you. Mr. Sharp, is Mr. Patterson here? Okay, go ahead, Mr. Sharp.
Thank you. Mr. Jeffrey Michael Patterson applied for an apprentice electrician license, and the department seeks to deny that application. The administrative law judge recommended issuance of a provisional license. For the following reasons, that recommendation is not appropriate and should be rejected. I'll try to just chronologically summarize Mr. Patterson's criminal history since it extends over a 30-year period. Between 1983 and 1988, the applicant was convicted of burglary with a habitation with intent to commit theft, and 3 different offenses of burglary of a motor vehicle with intent to commit theft. In 1997, he was convicted for possession of cocaine. In 2003, he was convicted of forgery of a commercial instrument, a $350 check from the account of Pollock Summit Electric Company in Houston. In 2008, he was convicted of theft. In 2009, the department took a chance on Mr. Patterson and issued to him an apprentice electrician license. In 2011, while Mr. Patterson was licensed by the department, he committed another theft offense and was convicted. A few months later, still in 2011, the applicant was again convicted of theft. In 2012, Mr. Patterson was convicted of theft under $1,500, third offense. In April 2013, the applicant was convicted of theft with 2 or more previous convictions, a felony, and sentenced to 14 months in state jail. In November 2013, Mr. Patterson was convicted of theft under $1,500, third offense, a felony. He was about 47 years old when he committed this offense, and the court sentenced him to 2 years confinement in the institutional division of the Texas Department of Criminal Justice. He was released from prison on September 26, 2014. On December 5, 2014, 2.5 months after his release from prison, Mr. Patterson applied for another apprentice electrician license. The Commission's criminal conviction guidelines identify crimes involving fraud or deceptive trade practices, which should include forgery, and crimes against property such as theft and burglary as offenses that directly relate to the duties and responsibilities of the licensed occupation of electricians. Mr. Patterson was convicted of having committed 1 forgery, 1 burglary of a habitation, 3 burglaries of motor vehicles, and 6 theft offenses, most of which were felonies. His crimes were directly related to the occupation of electrician. As the applicant, the burden was on Mr. Patterson to demonstrate his honesty, trustworthiness, and integrity. For that purpose, he offered 3 letters of recommendation. The first was from his employer of about 1 month, which said he was a good worker. The second was from a pastor of a church. Neither of those letters mentioned anything about Mr. Patterson's criminal history or even suggested the authors of those letters knew about it. The third letter was from a counselor who urged the department to give the applicant a license for the benefit of the applicant to help his rehabilitation. However, the relevant consideration under the law is not whether a license might help a person's rehabilitation, but rather whether a person has achieved rehabilitation and now has the honesty, integrity, and trustworthiness to hold a license. Also, the writer of that letter was apparently unaware of the fact that Mr. Patterson committed theft during his previous period of licensure. Mr. Patterson testified that he has changed, and the last time he was in prison, he vowed he would never return. However, he said he had also made a similar commitment during each of his previous prison or jail terms. In spite of a criminal career that spanned 3 decades and consisted almost entirely of burglary, forgery, and theft, the ALJ concluded that in the 2.5 months between his release from prison and the application date, the applicant demonstrated he now has the honesty, trustworthiness, and integrity to hold a license and should be granted a provisional license. Well, first, the department does not have the means to issue provisional licenses, and second, if it did, that license would only be provisional for 6 months, which would still not be enough time to measure the applicant's claim that he's rehabilitated and now has integrity. The department filed exceptions to the ALJ's proposal for decision and challenged improper or erroneous considerations and conclusions, such as the credit the ALJ gave Mr. Patterson for having, quote, successfully completed his jail and prison sentences, end quote, when Mr. Patterson did not have a choice about whether he was going to complete his jail or prison sentences. The department also emphasized that Mr. Patterson testified he'd been performing electrical work for his church and congregation members at a time when he was without a license to do so. The fact that the department and the public cannot trust the applicant to abide by electrician licensing laws diminishes the credibility of his claim and the ALJ's conclusion that he's now trustworthy and has integrity. Because of his extensive criminal history, the relatively short period of time since he committed his last crime, and the brief period of time since his release from prison, Mr. Patterson has not yet had sufficient time to establish a record of good conduct and demonstrate he has the necessary honesty, integrity, and trustworthiness required for licensure. The department recommends that you reject the proposal for decision and deny Mr. Patterson's application for an apprentice electrician license. Thank you.
Okay, commissioners? Questions? Motion?
I move that we, that the license be denied, and that we change finding of fact 28, that Mr. Patterson has not demonstrated his honesty and trustworthy with enough time, and then conclusions of law 11, and also conclusions of law 12.
Second that motion.
We have a motion and a second. Again, I'll ask if Mr. Patterson is here. Any discussion? Okay, all in favor, say aye.
Aye.
Aye. Any opposed? The motion passes. Moving to item G5, Ngia Nguyen. And Ngia Nguyen is here. If you would come up, please. I need to have you sign this. And also, if you're speaking for, if you would check that and you can sign it. Okay, Mr. Sharp?
Thank you. The applicant in this case is Mr. Nia T. Nguyen. He applied for an apprentice electrician license. The administrative law judge recommended denial of the license application. In 2005, Mr. Nguyen was convicted of possession of cocaine and sentenced to 180 days confinement in the Harris County Jail. In 2013, the applicant was convicted of sexual assault and sentenced to 2 years in prison. In that incident, the applicant and a friend had stopped to help a very intoxicated 22-year-old woman who was outside a bar with her friend. When the intoxicated girl's friend went back into the bar to arrange for transportation, the applicant and his friend drove the intoxicated woman to a motel room and left her there. The applicant, however, returned a short time later and sexually assaulted the still very intoxicated young woman. Mr. Wynn was released from prison on January 7th of 2015. He testified at the hearing that he has a lot of debt and he wants an electrician's license so he can make more money. He presented no evidence of rehabilitation. Crimes involving prohibited sexual conduct are directly related to the duties and responsibilities of electricians under the Commission's guidelines, and they authorize the Commission to deny a license application. The applicant's conviction also justifies denial of the license application under 2 other separate provisions of the Occupation Code because it involved a sexual assault. The ALJ concluded that because of the nature of the applicant's most recent offense, the short period of time since his release from prison, and the absence of any evidence of rehabilitation, Mr. Wynn's license application should be denied. The Department recommends that you adopt the PFD as written.
Commissioners, any questions for Mr. Sharp?
Make a motion to adopt.
Well,
Mr. Wynn is here.
He's gonna make a-
I just had him signing the comment deal. He just needs to sign it. And then, Mr. Wynn, if you would, please come up and we'll give you the opportunity to speak. Okay, Mr. Wynn, would you like to make a comment? Would you please state your name too, and then any comments that you make, if you would keep it to what was presented at the SOA hearing?
Yes, ma'am.
And you might pull the mic closer to you.
Yes, ma'am. I would like to have a license so I can go to work and support for my family. I just want to be better than I was, and you know, I just try my best to take care of my family. That's it.
When were you released from prison?
Tomorrow is a year.
I think maybe my concern at least is that it hasn't been that much time since you've been released from prison. I think it's great you want to provide for your family, but that's 2 very serious charges with just not very much time outside.
Commissioners, any other questions for Mr. Wynn? Okay, well, I'll entertain a motion.
I'm gonna make a motion to adopt the PFD as presented.
Do I hear a second?
Second.
All in favor, say aye.
Aye.
Any against? Motion passes. Thank you, Mr. Wynn. There is an opportunity for appeal, and if you are interested in that, you can, I'm sure one of our staff can help you with that. Thank you, Mr. Wynn.
Yes.
Moving to item G6, Bernardo Reyes. And is Mr. Reyes here? Bernardo Reyes. And Mr. Sharp, if you'd like to go ahead.
Thank you, and it is with perhaps a measure of mercy that I promise I'll try to be as brief as possible on this one, and it is my last one. Mr. Bernardo Reyes, the applicant in this case, applied for an incident management tow operator's license. The administrative law judge recommends the Commission deny the application. Mr. Reyes previously held a tow operator license from June 23, 2010 to September 13, 2013, when his license was revoked because of a criminal conviction. Mr. Reyes applied for a new incident management tow operator license on December 2, 2014. The applicant was convicted of obstructing a highway passage in 2001 when he was 21 years old. He'd been arrested for driving while intoxicated, but pled guilty to the reduced charge. The court sentenced him to 90 days in jail, but probated the sentence for 24 months. In July 2011, the applicant was convicted in the Tarrant County District Court of possession with intent to deliver a controlled substance of 4 grams or more, but less than 200 grams of cocaine. This conviction resulted from a drug raid in which police confiscated 114 grams of cocaine, scales, plastic bags, a handgun, and $1,500 in cash. Police found a 5-year-old child in the home at the time of the raid, although the applicant was not present then. The applicant was sentenced to serve 114 months in the Institutional Division of the Texas Department of Criminal Justice. He entered prison on July 8, 2013, and was released on parole November 5, 2014. He'll remain on parole until 2022. Crimes involving the delivery of controlled substances are directly related to the occupation of tow operator under the Commission's guidelines for license applicants with criminal convictions. The applicant testified he got his tow license in 2010 after he'd been arrested for the drug charges, but before he was convicted. He said he operated a tow truck for about 3 years before his conviction was finally upheld by an appeals court and he went to prison. He presented 2 letters of recommendation from the manager of a towing company and his wife, also an employee of that company. They recommended the applicant for his job skills, but made no reference to his character, honesty, integrity, and trustworthiness. They did not indicate having seen any changes in the applicant since the police confiscated the cocaine, cash, and gun from his house. In fact, they did not mention anything about his past or his convictions, but instead focused on the needs of their company and the applicant. Otherwise, the applicant presented no evidence of his conduct since his release from prison and no evidence of any rehabilitation. After consideration of all the evidence, the ALJ concluded the applicant had not demonstrated he has the honesty, integrity, and trustworthiness to hold a license at this time, and recommended the denial of his license application. The department recommends that you adopt the PFD as written.
Any questions, Commissioners?
Move that the PFD be adopted as recommended.
Second?
Second.
All in favor, say aye.
Aye.
Aye. Any opposed? Motion passes. Unanimous.
Thank you for your patience.
Thank you, Ken. Moving to item 7, Atlas Towing and Storage. Michael Schur. Mr. Shirk, I'm going to let you go ahead and go first.
Commissioners, good morning. My name is Michael Shirk. This case comes before you on a Towing and Booting Act violation. In this case, a proposal for decision was issued on November 10th, 2015, in which the administrative law judge found that respondent Atlas Towing and Storage had engaged in 2 tows in violation of the Towing and Booting Act. Prior to the hearing, or the hearing itself was held on August the 3rd, 2015. The record, the evidentiary record, closed on September 14, 2015. Neither party filed exceptions, and as mentioned, the proposal for decision was issued on November 10, 2015. Specifically, the case involves 2 Class F violations, which are treated as first violations given respondent's enforcement history. They involve towing in the absence of, among other things, legally adequate signage. Neither party filed exceptions. Staff recommends that the proposal for decision be adopted as written. Thank you.
Thank you. Commissioners, any questions for Mr. Shirk? If not, we'll move to, who would like to testify on behalf of the...
Commissioner, I'm David Fritchie. I'm the counsel for Atlas Towing and Storage, and have a brief presentation based upon the record in the case.
Okay.
I'm here accompanying, good morning, Commissioners, all Commissioners and staff, Mr. Shirk. I'm here with my client representative today, Mr. Ricardo Venegas, and his wife is here too, Olga Venegas, sitting in the back row, who works with him in this business. Atlas Towing tows about 1,500 vehicles a month. We're here today about signage. This commission, as I have sat here, has considered some very, very serious matters in the 6 cases preceding this case. We're talking about an issue, one tow in 2013 and one in 2014, one of which the sole basis for the TDLR prosecuting this case was because the signage had a de minimis difference from the statutory language. All the language was there, but it was out of order. And if I may approach, we have copies of Exhibit 17 that I would like to hand out.
Was this presented at the SOA hearing?
Yes, and admitted by
I believe so.
Prosecutor Shirk. There is a de minimis difference in the signage issue. It is de minimis in that the sole basis of the TDLR's complaint on this sign was it did not state verbatim the statutory language. All the words in the statute are in the sign: abandon, inoperable, or the like. They're just out of order. Now, I would ask the commission, in considering upholding, if the commission is going to uphold the ALJ's recommendation, I'd ask the commission to look at this sign and ask yourself, does this sign adequately and completely inform the consuming public that enters this parking facility of the type of vehicle that's going to be towed? There is nothing misleading. There is nothing deceptive. There is nothing criminally negligent about the signage. This is the sign that we're talking about. After you have considered 6 cases involving crimes from aggravated assault, possession of cocaine, we're here now about 2 signs. And I would like to read into the record from the transcript of the tow hearing 3 statements. First, at 1 hour, 7 minutes, 12 seconds of the hearing, Officer Michalik, who is the San Antonio police officer who investigates towing issues in San Antonio, was on the stand, stated in response to my question, was it okay for them to patrol the property at that time? Yes, was the response. So it was okay to patrol. And did she, the complainant, or the person who was towed, indicate that there was any issue with the understanding that under a patrol, Atlas could make the tow? Michalik, under a patrol, Atlas is allowed to make the tow. As far as that particular space, she did indicate it was a parking space. Second area is beyond the 1 hour, 8 minute, 50 second questioning again of Officer Michalik. So I'm clear, there are 2 entrances to this apartment community you testified to. Response, yes, sir. My question, is the signage at the, I would call it the primary entrance, where the monument sign is, and the signage at the ancillary entrance, does it have the same wording based upon your investigation? Michalik, I always check that, so if there would have been a discrepancy, I would have had it in my notes. Question, so both signs would have had red curbs, or tow zones? Yes, sir. The same sign at every entrance, and we are here talking about fining this company $2,000 on a tow that happened in 13, a tow that happened in 14. In fact, I would ask you to take notice of what the ultimate proposal for decision was by the ALJ, where Judge Arnold said there's no reason to even consider, which is what TDLR wanted, to suspend the license. The respondent refunded all fees associated with each tow before the staff began an enforcement action against it. The fees were refunded. Yet staff continued and took up the complaint, filed a complaint, and prosecuted it before the ALJ judge. And then 13C, the tows were unlawful because of the inadequacy of signs maintained on apartment complex property by the apartment management, not because of intentionally wrongful acts of the respondent. I would ask the Commission to disregard the findings of the ALJ judge, and in this particular case, dismiss the proceedings, or any alternative, reduce the fine to some de minimis amount as the signs are de minimis. After sitting and listening to some of the serious nature of what this commission has to consider on a regular basis before you, in particular these 6 cases this morning, I'm frankly professionally embarrassed to have to sit before you on signage. I would ask the Commission to dismiss this case, or if the Commission is not inclined to do so, do some sort of equitable reduction in any fine or assessment as to the respondent. Thank you. And Mr. Venegas is here to answer any questions if the Commission has any questions. Thank you for your time.
Mr. Ritchie, I also understood that the signage was placed too high.
It was.
And that the parking lot entrance was too wide, and that there was inappropriate signage. So not only was it the wording incorrect, but there was also some other issues with the signage. So it
If I may
wasn't-
address that, Commissioner Morgan, I have Exhibit 10, which was introduced by TDLR, that I would like to show the Commission, if I may approach.
Was that presented at the SOA
Yeah,
hearing?
he said it
Okay,
was.
okay.
Yes. This is the entrance and the signage that is at issue. So part of the issue is from what location is the signage measured? And whether or not, and remember, this is placed not by the respondent and not controlled by the respondent. It is placed by the apartment management. Now, that is a unique set of grades there where that sign is posted. You've got a retaining wall coming off the curb and the sidewalk of Blanco Road in San Antonio. And the sign is then posted based upon where the actual bollard is to hold the sign. And I don't think there was any evidence at the time of the hearing that the signage, if measured from the bottom of where the bollard enters the ground on where it's placed, I don't think there was any evidence whatsoever that in fact it was at the wrong height based upon where it is mounted, where it is installed on this property. I would also point out, and I don't want the Commission I want them to differentiate. We're talking, this is tow number 1, the Seville Apartments, where there was raised an issue about the entrance. You can clearly see that there's one entrance to the right of the monument sign. I also want to point out that as to the second tow, the only allegation by the department is the language in the sign, not where it was placed, not how it was installed. And you have before you as Exhibit 17, Exhibit 17, the signage at issue in the second tow, which is identical actually to the signage in the first tow. So, there is a practical issue on the installation of this sign. Where could you possibly put it? There's no evidence that it was not at the proper height based upon the fact that the pole was in the ground at a certain level. And I don't know that there is, other than putting up an entrance to a ranch and putting some big arch or something, I don't know how better you could possibly inform the public with regard to this signage. And there was another entrance that was properly marked that's not at issue. Tenants at this property regularly use that entrance, and it's not like, the particular tow here was of a tenant. There's no issue or allegation that she never saw this sign. So the only reversion of the department with regard to this tow is respondent towed without a proper sign. Ms. Bailey White was a tenant. She had a lease with parking requirements. There's nothing more I can say. She had notice. So what was reverted to is, well, we can't get you on that tow, but we're going to try to get you on this de minimis issue with the signage.
What is the difference? Do you have what the wording should have been compared to what it is?
Commissioner Yurko, yeah. The ALJ went into some detail in this beginning at page 4, and this is not the first time that we've had a proposal for decision come to the Commission and be adopted by the Commission, which found a violation because the language was not as authorized by statute. Chapter 2308.301B5 has 3 sets of phrases which the legislature saw fit to put within quotation marks. And what the administrative law judges found was that when the legislature put that phrase in quotation marks, okay, the phrases
I
are...
agree that we're not an issue. I think he's already conceded that the wording went the same. I'm just trying to determine how different this sign was from what the legislature would have.
The legislature required the sign to say, unauthorized vehicles will be towed at owner's or operator's expense. Simple, plain, uncluttered language. I would also point out that this sign does contain deceptive or illegal terms. For instance, all red curbs are tow zones. You can't color code parking lots just because of the sign that you have out front. If you wish to have specific designations of tow zones, the law states that those parking spaces have to be noticed as tow zones. The entry sign to parking facilities is supposed to be clear, concise, and put drivers on immediate notice while they're making a turn and looking at a sign that's, 24 by 18, that who is authorized and who is unauthorized.
Okay, question. And I'm not sure who could answer this better. What happened to the actual citizen with regard to the tow? Did she have to pay for the tow? Was she reimbursed? What was the situation?
She was reimbursed before the department began its prosecution of this case.
Okay. And then, if the signs would have been correct, would the tows have been lawful then?
The tow exhibit in Exhibit 17 would have been lawful. That was the tow of July 29th, 2013. The second tow of October 15, 2013, because of the height variations and the inadequate spacing, the entryways were more than 60 feet, would not have been.
Okay, who's in charge of putting it, who does the legislature require to put the signs up?
The signs are posted by either the tow company or the parking facility.
Okay. Did anyone determine who did the, you said the parking facility, that would have been, I guess, the...
The apartment complex.
Apartment complex. Did anyone determine who put up the sign?
No, I'm happy to assume the apartment complex put up the sign.
Okay, did we consider pursuing charges against the apartment complex?
I don't believe we have jurisdiction to go after a parking complex.
Well, if the legislature said either one can put up the sign and they made a mistake on the sign, could we not do the apartment buildings?
Well, the tow owners, the tow operators are given continuing education that signs must meet statutory requirements, otherwise the tow is prohibited. And so even if they put up a faulty sign, the tow operator's on notice and under a continuing responsibility as part of the license not to tow.
Okay. What was the deal with the height? Was it too high?
Yes.
Because looking in the picture, based on the ground, it doesn't look that high. And I understand there is a berm there, so it looks like, are you basing it from the public street level or the entrance height?
From the street level, as the administrative law judge found, by incorporating a previous decision or previous PFD adopted by the commission, the measurement should be from the street level in order to ensure that the sign is conspicuous to owners and operators when they enter the facility.
But if you put it at the street level from the street with that hill coming up, then you would have the sign almost underground or on the grass.
I don't
Correct?
believe that that's the conclusion of the administrative law judge or of Detective McCulloch, who rendered his findings and conclusions about the visibility of the sign.
Yeah,
It just doesn't make sense.
From what I was reading on it too, and I mean, looking at the sign and being on the berm and everything, from ground height on the berm, it looked normal, but if you're a driver from the street level coming in, it's too high.
But as you come in,
But as you're
you're gonna see it. If it's down below, you're gonna totally miss it.
But then you're coming up on a kind of a hill
Elevation.
turn-in.
Right.
So it's kind of a variance there, but from what the detective said, as a driver, it was too high to see, and so that's what, was, the detective said it was,
And
beyond the
Commissioner
6 feet.
Yurko, I think also what's relevant with the sign height is that the driveway itself, the curb cut was in excess of 60 feet, and there was only one sign. If there had been another sign, that might have
But was,
been more notice to the operator.
but wasn't the sign on the right side of the road? I mean, that's where you turn in, so it's, I guess what I'm saying is for a penalty of $2,000 each, which seems to be like, this is a terrible crime, this should never have happened, should never happen again. It seems like everyone was making their best, attempts to put in the sign according to what was required by statute. And I'm kind of wondering, since this happened, has the department moved the sign?
I don't know.
Have we made sure, we put it where you all want it to be? Because it seems like this problem's gonna be a recurring problem if we haven't lended them any guidance as to where that sign should be. Because the reason why I'm asking that is I can't imagine you'd put that sign anywhere else but there, at that height. Because if you put it from street level height and you drive up that hill, that sign's gonna be below your vision. And while you may not have seen the sign from the street when you turned in to park, it would have been right there in your face. So I'm curious as to what our person thought where that sign should have been.
I think the administrative law judge addressed that in his proposal for decision. I think Detective McCulloch also gave advice to the parking facility about where the sign should have been placed.
And where was that?
6 feet, or with the bottom edge no higher than 5 feet from street level. It could have been posted against that berm, against those
Right, so it
bricks.
would have been on the grass.
Wouldn't be on the grass.
Well, I mean, you look at the hill,
grass
I
was 8
bet
feet
that's
off.
4 feet.
Yeah.
So, I mean, I really can't imagine where else you'd put the sign.
I understand. I presented my case. The administrative law judge made factual findings. I will say, with respect to the penalty, this is the first violation. The department uses the penalty grid that we've been given to work with. The purpose of administrative proceedings, as opposed to, say, criminal proceedings or civil law proceedings, is to effectuate specific and general deterrence, that is, to ensure compliance with the law. If respondent is making somewhere in the area of 1,200 tows per month, and each tow is at $250, $2,000 may effectuate some deterrence. It's not, and that's the purpose of the penalty, both the grid and
Okay,
the
okay, I
penalty.
understand that, but I guess I go back to, if he's making that many tows and this is the only crime, do we not think that maybe this seems a little excessive?
And I
Respondent has
think,
been here before.
yeah, I think it's up to the commission too. If we want to adjust that penalty, we can too. So, and I think, Mr. Venegas, were you wanting to make a comment? Or you look like you were wanting to say something.
Everything that's been said by Miss Deborah Yurko is basically what I wanted to say, that there's no possible way of positioning that specific entrance sign other than being, and again, once again, in violation where it's not visible to the driver as they're pulling in. That's it.
Commissioner Shaw, did you have a comment?
Yes, I did. Yes, I did. Thank you. First of all, signage is a requirement. It is a state statute, so I appreciate all the comments about signage, but it is a state statute. In fact, specific fonts may be required, and if you violate those, fonts, you could be fined for that. If you're in my jurisdiction and if your signage was wrong, we would fine you for it. So signage is a requirement. However, I do agree that the sign height, sign placement, and the performance of that sign functions as it does. I think we issue many sign permits in our jurisdiction, and Ms. Yoko, I would love to hire you as our sign coordinator if you want to come and work for the city of Carroll.
Depends what you want.
Because that sign does not, in my opinion, when you say street level, that is about 3 to 4 feet height, and you would be seeing that sign at 3 feet, and by the time you get to the top, your eye level will be above the sign, so I'd have to agree with that. A couple more comments. I think the commissioner mentioned something about, what about the apartment? And what are they doing to rectify this issue with the inappropriate signage? Are we following up with them? It's been 2 years. Is the sign still up there? From what I
Oh,
understand.
wait, I think he was gonna answer you.
No, that's okay.
I'd like to know it.
Yeah, I'm gonna come back to him. I wanna finish my stuff.
Okay.
Thank you. And he can wait. Okay. From what I understand, the tenant was refunded the money. The tenant was given back the money. I think it would be my recommendation to the commission to adopt the PFD, but look at a reduced fine. And I would entertain a motion for that if there is one, but I would like to look at maybe reducing the fine to $500.
I have a few questions, if you like.
Yes.
Wait, I first wanna hear the answer to
Please.
that. What about the sign now?
As far as know, the detective did not require anyone to move anything. There was no citation issued to either us or the property.
No, is the same sign still up there, or is there a different sign up there now?
I believe the same sign is still up there.
Do you still have a contract with that apartment complex?
We have for the past 11 years, yes, ma'am.
Do you worry about the liability of that signage?
Well, since the detective did not require us to remove it, and when we explained to him exactly that, where if we were to place it at street level, then it would not be visible to the drivers as they enter the facility.
Because the wording doesn't comply with the TDLR.
Yes, ma'am. The verbiage is one word. Instead of it being continuous, unauthorized vehicles will be towed at owner operator's expense. It says unauthorized, abandoned, inoperable, improperly parked vehicles will be towed at owner operator's expense. We believed strongly that the more that the sign had, the better it would be for the public.
I'd have to stop and read it. I mean, when I pulled in, I'd have to stop and sit there for a minute to read it.
We only post,
I couldn't read it if I was pulling in. I'd have to stop. So, I mean, if I were you, I would advise that you cover yourself and change it to the correct sign. So, but as a tow company, they can change it. Commissioner, Tom had a.
Commissioner Tom.
Oh, yes, sorry.
Is it Mr. Benavides?
Venegas.
Venegas, I'm so sorry. Okay, so you answered one of my questions. You've been there for 11 years?
Yes,
Atlas?
sir.
And I'm glad you've only had two problems in that 11 years. How many tows do you think you do from this apartment complex in a given year?
Oh, Lord, probably, I'm gonna say roughly about 20 to 25 tows per month from that property.
20 to 25 per month?
Yes, sir.
Wow, okay. And so how many from this particular spot would you guess?
Are you talking about this tow that was at issue here?
No, sir, that's parking spot with the inartfully worded sign.
Madam Chair, this is Brad Bowman, General Counsel. I hate to interrupt, but I just want to make sure
Just at this one.
are we veering off of what's in the actual SOA record?
I don't think that was discussed in the SOA hearing.
Was it not discussed at all? And so we can't ask that question for our own edification in terms of assessing a fine or not assessing a fine?
I think our policy has been to stick to the record, but
I'm just trying to put it in some perspective. 11 years, how many tows, how many at this particular sign?
I understand.
Brimstone gonna fall down if I ask this question?
I'm not going to try to stop you, I'm just,
Do you really want to incite him to anger?
no, I don't. But no, just to answer that, typically we try to stick to the administrative record. I don't know what harm there would be in this particular case of deviating from it, but it's,
Just trying to be fair to all parties here and trying to get some perspective. I think you understand where I'm coming from. Just kind of want, how many, from this particular spot, the one that we're talking about with that sign, or where the two tows originated, correct?
No,
Yes.
Commissioner, I do want to clarify that. These were two combined cases at the request of TDLR.
Okay.
One case is the one that we're talking about at the Seville Apartments that has this problematic placement.
Sure.
The second one was at Springwood Apartments, totally separate, and the sole issue in that case was not height or anything. The sole issue was the verbiage.
Sure.
And as Mr. Venegas pointed out, one word is added, right?
I understand that it's de minimis to everybody, but those that got their cars towed.
Well, and if I could
Right.
address that?
So- Yes,
Because-
please do.
Yes, because Commissioner Yurko brought up a point about this, and as did Prosecutor Shirk, when he said the consuming public has to be aware of what the rules are with the signage placement and what's on the sign. I would concede that if the tow, in this case, was initiated as against a guest or invitee, in other words, somebody that's never been there before. Ms. Bailey White was a longtime resident of the Seville Apartments, so I can't concede what Prosecutor Shirk said about notifying the public, because I think that if we were talking about a guest, that's a different story. We're talking about a tow that occurred that prompted this entire issue of a longtime tenant who parked on a red curb, and that's what initiated this. And I did want to differentiate the fact that we're talking about two different locations,
Sure.
two different apartment communities.
But the management didn't instigate the tow, correct? And that's, I guess what I'm thinking is, we can't have it both ways. We can't point to the sign and say that's justification for the tow, and then when you make the tow, they point to the sign and say, but the sign's not correct. So you can't use it as a license to tow, and then turn around and say, we're gonna give you back your money because it was an unfair tow. Have you given back everybody's money who you towed because of this license, or just the two that made an issue of it?
Well, I think Mr. Venegas could talk to that point.
Again, was
about
this items that was discussed is so inherent? I think we really
It was
need to
not in-
stick to those items, because if not, we're going to get way off base.
I think he answered that, 20 to 25 tows per month at this location. And
Commissioner
we're-
Moses, did you have a question?
with no complaints, except this one in 2013.
One thing I would like to clarify, Commission, is that when they asked if this exact sign was still at that location, no, this is not the same location, but not the exact same sign. The sign was corrected as soon as there was an issue that was brought up. The intention was not to try to confuse the public, or that is not the intention of the towing company. It was, we wanted to give them a broader, more information. We felt that the more information they had, the better chances of them not being towed for them.
Okay. All right, let me see, my question. I think there was some kind of confusion. My experience owning a commercial property is that, is this your sign, right? This is the sign that you put up?
No, sir, this is the
Is
sign
this the
that
sign?
the community, residential community posted.
They put up?
Yes, sir.
Although you have a contract with them?
Yes, sir,
And
we
they asked you to
have.
come by and do the towing for them?
That's correct.
They put up this sign, and it's not your sign?
It is,
Who changed the language? Did they change it, or you changed it?
they had everything done.
Okay, all right, okay. Okay, so, okay, in this case, they put up the sign, is that right?
That's correct.
You have a contract relationship. But there's also, I guess, not so much in the case, but there was a question about who authorized the tow, whether it was done by management or whether it was done by a patrol. And it was done by somebody patrolling the
This
area, right?
community has specific problems, sir, and they particularly wanted us to enforce these parking rules and regulations. So they
So-
initiated the tow. However, we have the right under the agreement to patrol the property.
And exactly, and the tow was acted on based on the patrolling.
That is correct.
Of the property, yes, okay. Okay.
Okay, Commissioners, any other questions? Comments? Yeah,
I'm ready to make a motion.
okay. I'll entertain a motion.
Well, based on what I've read, but what I've seen and the pictures that were submitted here, which were also submitted with the ALJ, and based on what I understand, what has transpired in here, I think I'm willing to say let's adopt the PFD as proposed by the ALJ, because it clearly notes that the sign is not exactly what's in our legal statute. However, I am willing to look at the administrative penalty that has been assessed. I believe it's very high, and I would just throw out a number. I'm not sure if this is the right number or not, but I would think of it as maybe a $250 total fine for that.
Second.
Third.
Okay, any discussion? Have a motion, a second. I feel like a $250 fine is a little bit low.
I think it is, too.
I think 4,000 is way too high.
Yeah, I think it's too low also, yeah, I really do.
Madam Chair, was it 250 total or 250 per
250 total?
violation?
No, he said yeah. Yeah.
I was thinking total, but I'm willing to listen to.
I would think maybe $500 per, each, so 1,000 total.
As a motion maker, I think I would not agree with that.
500, guys, let's just split the baby.
As a
I love
motion
this
with-
country. How about we just meet halfway? We go 250 for each sign and call it done.
Okay, who made the second?
I did.
Okay, second.
I thirded it.
Okay, do you agree to that?
Okay.
I said,
Okay, we have a motion and a second for $250 for each violation. All in favor, say aye.
Aye.
Aye. Opposed?
No.
Make my 250. I thought we were splitting that
no.
baby up.
Okay. Okay, the motion passes 4-2.
That's fine.
Madam Chair?
Why did we do
Yes,
that?
ma'am. Yes,
Just
sir.
for-
Yes, sir.
Just for a technical
Wait,
basis, could we get a withdrawal of that first motion?
Okay, yes.
I don't think we should vote on that one.
Okay, yeah, let's vote on that, okay.
Okay, for formality, could we have a withdrawal of your first motion?
Well, no, I want to withdraw my second motion.
That was been voted
I
on.
think, Ms. Bradbourne, I think what has to happen.
Well, could you have voted on this, could you have voted on the second one
So-
without
so-
withdrawing the first one?
Yeah, if there's an amendment to the motion, that has to go back to the motion maker and then to whoever seconded.
Okay, yeah, we
So-
did
I
have an
agree.
amendment.
I agree.
Well,
For
It
the
wa-
500, and was that,
It was actually amended by Commissioner Shaw and
Right.
Commissioner Yurko, is what we had done.
and okay, so we had then I
But-
think we're.
Are you comfortable? Okay,
I
I'm
think
good
we're-
then.
So we don't need to withdraw, correct?
I'm good.
Because they did amend their motion to
We did amend
include
it.
If we had,
250
yeah,
to-
if
per
Commissioner
violation.
Shaw and
And Commissioner
You wanna start
Yurko.
over?
Commissioner,
Why don't we start over?
Yeah, they amended it.
you certainly can start over if you want,
Yeah.
want to do that, and maybe
Clarification.
reconsider your vote and start over if you want to have
Do
a
we need to
clean-
reconsider it?
clean vote on
Or
that.
do you feel
I'm,
good with your vote?
Brad, I'm comfortable. I'll withdraw
Okay,
my withdrawal.
I'm comfortable too with the explanation.
Okay, let's, for the matter of time, unless you want to reconsider it, we'll go with the 4-2 approval of a $500 fine total, $250 for each violation. Okay?
Thank you.
Okay,
Thank you,
thank you,
Commissioners.
thank
May we be
you.
excused.
Thank you.
Yeah, thank you. Okay, moving to item number 8, Terrence Edwards, Robert Rennick.
Mr. Edwards is here, too.
Okay, and yeah, Mr. Edwards, if you'd like to go ahead and come up.
I voted no.
Okay, go ahead, Mr. Rennick.
Commissioners, there is a preliminary matter. Mr. Edwards was represented by counsel at the hearing, and to my knowledge, he still is, but his counsel is not here today. So I think Mr. Edwards might have a motion for continuance so that his counsel can be here. The department would not object.
Okay. Okay, Commissioners, does everyone agree to that? That his, Mr. Edwards' attorney's not here? Does anyone have a problem with that? Will we do it?
No.
Okay,
Okay.
I'd like a motion.
So moved as we continue this case.
Second?
Second.
All in favor, say aye.
Aye.
Any opposed? Motion passes. So we'll continue that to the next meeting? Or when the
yes.
attorney can be present, when your attorney can be present?
Yes.
Okay, so we'll make arrangements for
That We'll send notice to his attorney.
that. Okay, okay. Okay, moving to item number 9, Clinton Edward Graham and Robert Rennick, and is Mr. Graham here? Mr. Graham? Okay.
Is he
Mr.
here?
Rennick, go ahead.
All right. Thank you, Commissioners. This applicant seeks an apprentice electrician license. The ALJ recommends that you deny the application. In September of 2007, he was convicted of assault and sentenced to 365 days in jail. That sentence was probated for 12 months. The crime occurred in January of 2007 when the applicant pushed his wife up against a door frame after she saw him naked in her daughter's bedroom. The victim was the applicant's, well, the victim ultimately in another case was the applicant's stepdaughter, and that's the room where the applicant was standing naked. In 2007, also, the applicant pled guilty to 4 counts of sexual assault and 2 counts of indecency with a child, all felonies. The court found that the evidence substantiated the applicant's guilt but deferred adjudicating him and placed him on community supervision for 10 years. The victim of all 6 felonies was the applicant's stepdaughter. Crimes were the result of over 2 years of sexual abuse beginning when the victim was 14 years old. 2 of the crimes of the felonies were committed on the same day that the applicant assaulted his wife after she saw him standing naked in her daughter's bedroom. The department recommends that the commission adopt the PFD and deny the license. Take any questions you might have.
Commissioners, any questions for Mr. Rennick?
So,
I have, before we make a motion, I think there are some technical issues that are a problem.
Yes, this is Brad Bowman, General Counsel. There are, these don't affect the outcome, but conclusion of law 5, I'm sorry, finding of fact 5 and conclusions of law 9, 10, 11, and 12. We're recommending some technical corrections having to do with the legal citations and clarifying that the date that's referred to is the date of the guilty plea, not the date of the offense. Again, it doesn't impact your decision one way or the other. It's just some technical corrections.
I'd make a motion to adopt the PFD as written with the technical changes that our council has recommended.
second.
Is that okay?
Okay, we have a motion. Do I hear a second?
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Aye. Okay, PFD passes as recommended. Okay, moving to item H. If anyone needs to take a break, feel free to get up and take a break. Other than that, I'm going to continue moving forward for the sake of time, since I know that some of us will be trying to depart. So, if you'll feel free to take a break in the meantime, as long as we can maintain a quorum here. Motions for rehearing. The commission may consider and take any action related to the following cases. So we will start with item number 1, which Mr. Dung is not here today, so I believe we're going to go ahead and pass on that one. Is that correct?
He requested well, he did not request a continuance. He said he could not be here.
Or he just asked to reschedule the hearing.
Oh, he did?
Yeah.
Okay.
He sent a,
that
or
was
she,
Torres.
oh, that was Torres. That's
previously.
her, I'm sorry, that is Torres.
The-
He's not here today.
We received an email yesterday where he
Yesterday.
said he could not make it because his son is sick.
Sick, that's
He
right.
sent a copy of the inspection report. He did not ask for a continuance. If-
But it wouldn't affect the, if there's no statutory problems with continuance, I wouldn't have a problem with continuing.
Second.
We have a motion and a second to
Continue.
continue it. All in favor, say aye.
Aye.
Any opposed? Okay, so we'll continue Mr. Dunn's case. Moving to item 2, Erica Weaver.
Okay.
Is Erica Weaver here? Or
I don't believe so, no. My name is Pamela Gate. I'm an Assistant General Counsel. I'll be doing the motions for rehearing now, taking them over from Della Lindquist.
Okay.
This is a default order based upon Ms. Weaver's failure to respond to a First Amendment notice of alleged violation. The Executive Director issued a decision revoking her cosmetology operator license for failing to pay in full a previously assessed administrative penalty. She had paid $250 but failed to pay the remaining balance. Since that time, since she's received this, the default order and filed her motion for hearing, she has entered into a payment agreement with the department. She made payments of $150 on November the 5th, December the 5th, and January the 5th. She will continue making monthly payments until the balance of the previously assessed penalty is paid in full. And it is the General Counsel's recommendation that you deny the motion for rehearing, but that in the interest of precedent and consistency, probate the revocation for 1 year, conditioned upon her compliance with the payment agreement that she entered into, and with the cosmetology statutes and rules. So at this point, I believe she has $300 that she owes. She'll be making a payment in February and in March.
So move as recommended.
Second that.
Okay, we have a motion and a second. All in favor, say aye.
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 Any opposed? Okay. Moving to item number 3,
Okay.
Billy Ramirez.
This is a default order resulting from the respondent's failure to appear at a hearing before a SOA administrative law judge. The hearing was originally scheduled for June the 2nd, 2015, and was continued to August the 13th, 2015, at Mr. Ramirez's request. He was notified of the new hearing date by SOA, but he did not appear. On September the 30th, 2015, the Executive Director issued a default order revoking his journeyman electrician license. In Mr. Ramirez's motion for rehearing, he states he wasn't able to make it to the second, and I'm stating that, well, I will read it to you, but he said he couldn't make it to the second hearing date because he did not have a vehicle. He didn't allege in his written motion that he did not receive notice of the new hearing date, and so the General Counsel finds no error of law or procedure. We would recommend that you deny this motion for rehearing.
Okay, do I hear a motion? Motion to deny or to accept?
He did not have a vehicle.
Second failure to,
Is that second time? No?
He failed to appear at the actual hearing at SOA. That was his request for the continuance. He did not appear.
Make a
He-
motion that we deny his request for rehearing.
have a motion, do I hear a second?
Second.
All in favor, say aye.
Aye.
Any opposed? Moving to item number 4, John McKinney III.
Okay. This matter resulted from a hearing before a SOA ALJ, who ruled on the facts and applied the law to the facts and issued a PFD. The Commission issued a decision on October the 14th of 2015 and adopted the PFD without any modification. The decision denied respondent's application for an apprentice electrician license. In the respondent's motion for rehearing, he states that he has completed parole in the electrician apprentice program at Everest College and is moving to better his life. He alleges no error in his motion for rehearing, and the general counsel finds no error of law or procedure. We're recommending that you deny this motion.
I'll entertain a motion. Commissioners? Hello?
Hello, okay. I
Are
move
y'all
that
with
we-
me?
We deny the motion for rehearing. I don't think
I have a motion. Do I hear a second?
we don't have anything
Second
else to
that
go on.
motion.
And we don't have anything else to go on. Just
I have
say-
a motion and a second. All in favor, say aye.
Aye.
Aye. Any opposed? Number 5, Zigma Realty.
This is a default order based upon the respondent's failure to respond to a first amended notice of alleged violation. The decision of the executive director dated October the 12th of 2015 assessed a $1,500 penalty against the respondent for failure to have an annual elevator inspection in 2014. The respondent's motion for rehearing states that the mailing address for the notice is incorrect and was not received in sufficient time to respond. We received an email from the respondent's CFO who provided a mailing address that is the same address listed in the records of the county appraisal district. In looking at the records, they indicate that notice was sent to the address of the registered agent for Zigma Realty and also to the address of the contact person for this facility. However, notice was not sent to the address of the owner of the real estate listed in the county appraisal district records, although the CAD address is listed in the notice of alleged violation. Because the owner of the real estate is responsible for the inspection of the elevator, and the owner of the real estate was listed in the CAD records, but notice was not sent to the CAD address, the general counsel is recommending granting the motion for rehearing.
Move to grant the rehearing.
Motion and second. All in favor, say aye.
Aye.
Aye. Any opposed? Okay. Move to item 6, Isidro yeah.
Okay. This is a default order based upon the respondent's failure to respond to a notice of alleged violation. The decision of the executive director dated October the 26th, 2015 assessed a $2,000 administrative penalty against the respondent for performing a private property tow without the proper authority to perform the tow. This was a situation where the towing signs did not have the required wording on them. The respondent made a motion for rehearing and states in his motion that the towing signs include all pertinent information regarding tows and that the person whose car was towed was parked in a handicapped parking space. The respondent requests dismissal of the case without the necessity of pursuing legal counsel in this matter. The respondent's motion doesn't allege lack of notice or any other legal or factual basis for granting the motion for rehearing. Notices were sent to the correct address of record for the respondent, and the general counsel sees no error and recommends denying the motion for rehearing. And I would be happy to answer any questions that you have.
Commissioners, any questions?
Let's see, it looks like this was a default. They did not appear when they first got notice.
Right, they did not request a hearing. They did not enter into an agreement order. They were silent until they received notice of the default. Well, let me take that back. They weren't silent. They sent in some information, but they did not request a hearing. So I believe in the enforcement division said, you know, if you contest this, if you think this is not correct, then you need to request a hearing. And they didn't request a hearing. And they're simply sending in a letter saying, please dismiss this.
But, okay, so no action if we deny this, then it's the fine that they have to pay, right?
It's in the default order.
Yeah, in the default order.
Discussion?
Yeah. Okay, I think sometime we'll decide that. I'd be in favor of maybe granting them a motion for a hearing and considering trying to work this out, and we have better success in terms of collecting fines when we can make an agreement with somebody. I think we should at least have a discussion with them, further discussion.
Is there a second?
I'll second that.
Have a motion and a second. All in favor, say aye.
Aye.
Opposed?
Aye.
Aye.
Roll call?
Tom Butler,
No.
Luann Morgan,
Aye.
Fred Moses.
Aye.
Catherine Rodewald,
Aye.
Ravi Shaw,
No.
Deborah Yurko.
I know, I'm undecided too.
No. So it's a tie, so it's rolling.
So I'll reconsider my vote and say no. So we can, if they didn't take any action on it. I'm gonna reconsider my vote and say no.
If it's a tie, what happens?
Yeah, I reconsider
would've
my vote,
rolled.
so,
Okay,
yeah,
okay.
I said no.
Yeah.
Since they didn't take any action on it. I was kinda, like Commissioner Yurko, I was in between. So we moved forward with it. So it fails. Is that okay?
So
Yes.
this is Brad Bowman, General Counsel. You
Was-
could entertain another motion.
Okay, so we need to entertain another
So
motion.
that motion failed.
Okay, so that motion failed, and so, yeah, so we'll entertain another motion then. Thank you. Anybody have any questions for Mr. Francis? Okay, moving to item J, discussion of possible action to approve 3 revised penalty matrices in the elevators, escalators, and related equipment program for inspectors, contractors, owners. That's gonna be enforcement.
Yes. Good morning, Commissioners. I am John Medlock, a prosecutor with the Enforcement Division. I am subbing for our Director, Christina Kaiser, who could not be here today. But in item J, and I also have Chris Russi with me, he's going to bring up the different
Hi,
penalty
Chris.
matrix that we have proposed before you. But in item J, we have discussion and possible adoption of the updates to the elevator matrices, because there are 3 of them. One for the inspectors, one for the elevator contractors, and one for the building owners. As Christina has said in the past, with the last 2 matrices you have adopted with regard to the AC and the electrical, these put the industry and the public on notice of what type of violations that we pursue in the Enforcement Division and the types of penalties that we typically seek. These matrices do not create law, but we just take the words from the statute and put them in there, so they kind of have a general idea of what they're facing. The last time that the elevator matrix was published was April of 2007. Since then, we have had the elevator statute updated in every legislative session. In 2 of those legislative sessions, significant changes were made to the elevator statute in 2011 and 2013. In 2011, House Bill 2643 added insurance requirements for contractors. Contractor registration had already been there since 2003. This added the insurance requirement for those contractors. It added CE requirements for the contractors, added requirements that the contractors designate a responsible party for that continuing education, and also added plan reviews for new installations and alterations. In 2013, Senate Bill 673 added the authority for the Commission to adopt rules on several subjects, including standards for testing of equipment, in addition to installation, maintenance, alteration, operation, inspection, documents such as maintenance protocol, programs, manuals, testing procedures, and the manner of filing information with the Department, including via electronic means. It also made several changes regarding the building owners, including reducing times that they had to file the annual inspection reports and reporting of accidents. Also made several changes relating to the inspectors, including also reducing time limits for them to submit their inspection reports to the owners, and added the express requirement for the CE for inspectors. Previously, it was only a one-time requirement for those people. And it also added disciplinary action for registrants or for certain things such as obtaining registration by false or fraudulent means or falsifying records. The elevator rules have been amended 6 times since the last publication of this matrix. Out of those 6 times, 3 of them were significant, had significant impacts on these matrices in 2008, 2012, and 2013. Generally, the rule changes incorporate the changes that occurred in the statutes and further beefed up the safety responsibilities of the owners, contractors, and the inspectors. Several of the big themes with regard to this include reporting times to the department, including accidents, reportable conditions, and equipment found without decals, taking equipment out of service regarding accidents or reportable conditions. Also shorten the deadlines for actions relating to the inspection reports and reportable things to the department, plan reviews, documentation relating operations and upkeep of the equipment, testing of the equipment. And beyond what these statutes and rule changes have done, we've also done a couple other things that will look familiar. We've added the subject matter headings to better group categories of violations together, so it makes it a little bit more clear for the public. We've also moved some violations into higher classifications and also moved some down based on the seriousness of or the less seriousness of some of these violations. We presented this before the Elevator Advisory Board on December 15th of 2015. They approved it for your consideration today. In addition to what you have, some of the things that were highlighted in the report to you, and I don't know if Chris has it where it's highlighted, but if you see on where it says per unit of inspection, that was originally only on the building owners, but we added it to each of these matrices for the inspectors and also the contractors, because the Elevator Advisory Board wanted to make sure that we weren't just talking about, because like sometimes hotels will have groups of elevators, and they wanted to know that a violation was on each elevator, not just one group of elevators as a whole. Also, anything that's italicized is based on the proposed rules that y'all will be seeing in an agenda item in today. So if y'all approve those rules today, those will be included in this matrices if you all approve these matrices as well. If you don't approve the rules, those won't be included if you go ahead and adopt this matrices as well.
John, let's also add that if they approve the rules and make an amendment, then we will also make that.
Right, that's correct, yeah.
That change to it as well.
If you amend any of those rules relating to those sections, obviously those will be amended as well.
Thank you.
And then finally, we also added a Class D section against the building owners. Previously, this section wasn't there, but it's there to kind of mirror what we have for the inspectors and the contractors. And it represents things such as violating previous orders of the department, obtaining false or fraudulent documents and things of that nature. So I can kind of walk through some of the changes if you would like me to, or I'd be happy to answer any questions that you may have on these.
Question?
I have just 2 questions. First question is, when you say per unit of equipment, I want to make sure that that's never misunderstood in the future. What you just said was it was per elevator.
Correct. Each elevator has a decal, and each building has what they call an ELBI. And so every time we go after an elevator, we go after that specific decal.
Okay. And can you tell me the reason for including a penalty matrix for the building owners, and have we done any notification to BOMA on this?
BOMA would have got notification through the advisory board meeting. I know that one of the lobbyists that we work very closely with is on the listserv, so would have received that information. This, as Christina typically lays out when she does a presentation, is not creating new rules or new provisions. It's simply putting, the ranges attached to it. Also, on the advisory board, there are 2 building owner manager representatives that are on the advisory board, so they have a voice as well.
Thank you.
Does anyone want to go through a list of the changes? Okay. Any questions? So no action until we move to item N, correct?
Well, you can go to adopt these, and if y'all make any changes to that, we will subsequently make those changes as well.
Okay, so.
in the specific items that are highlighted, or not highlighted, but they're in italics. There's not a whole lot. There's about 4, I believe, with regard.
And to adopt these would be an item N, is that correct?
You can adopt them here contingent upon any changes
Okay.
to the rules that are going to be presented. And I think that-
Is that under item N, is that correct?
Yes.
Okay, so
Yes,
that'd be, so let's just go ahead and do that then, discussion and possible action, under item N, discussion and possible action on proposed amendments to existing rules at 16 Texas Administrative Code, Chapter 74, 88, 7410, 7450, 7455, 7469, 7474, and 7480. Proposed new rule 74105 to implement changes made by House Bill 3741 and make editorial corrections regarding the elevators, escalators, and related equipment programs. Commissioner-
Madam Chair,
Uh-huh.
I apologize because I may have misunderstood what you're
Uh-huh.
asking.
Oh, okay.
The motion that we're asking right now for this particular item
Is
is
for-
adoption of the penalty matrices, subject to any
Penalty.
changes under Section
Section-
N, and then Charles will come up and present Section N.
N,
subsequent.
okay,
Yes,
I'm
and I
sorry,
apologize
yeah, I
for that.
misunderstood, okay. So this is just to adopt a penalty matrix under item J. So
Yes, ma'am.
I'll
Yes.
back up then. So discussion and possible action to approve the 3 revised penalty matrices, which was in elevators, escalators, and related equipment program for inspectors, contractors, and owners. Commissioners, do you want to go ahead and approve that penalty matrices as proposed?
I will. I make the motion to go ahead and adopt those, adopt the matrices, and I think there was an effective date on that. Am I correct?
They're usually not an effective date, listening to past conversations. This will just be published in the Texas Register, and then we will put it up on the website.
Okay, very
That's
good.
correct.
I think, just as part of the motion, this is very important, very critical. I think the life safety of elevators is very important, so.
Yeah. Is there a second?
Second.
Okay, all in favor signify by saying aye.
Aye.
Any opposed? Any discussion? Okay, sorry.
Thanks.
That confusing there.
Great job, John. Good job.
Thank you. Thanks, John. Moving to item K, discussion and possible action on proposed amendments to existing rules of 16 Texas Administrative Code, Chapter 60, Subchapter G, 6102, Subchapter L, or I, 6300, 6302, 6304 to 6308, 6310, 6311, and proposed repeal of existing rules on subchapter I, 6301, 6303, and 6309 to implement changes made by the 84th Legislature regular session in 2015 regarding the procedural rules of the Commission and the Department.
My name is Laura Pepperly with the General Counsel's Office, and these amendments to Chapter 60 remove and repeal certain provisions that conflict with or have been changed in the Administrative Procedure Act. There were a number of changes in the Administrative Procedure Act from the last legislative session, and so this rulemaking implements those into Chapter 60. The rules were published and the comment period began on October 23rd and ended on November 23rd. No comments were received. The legislature had made significant changes, and the objective of the rule changes was to, as I said, eliminate redundant or conflicting provisions in Chapter 60. So basically there is a lot of material removed. The advantages of that are mainly that any interpretations of the Administrative Procedure Act by the Attorney General or a court for any entity subject to the APA won't conflict with Chapter 60, and the Chapter 60 rules won't be interpreting the APA. And so the APA, Chapter 51, and SOA's rules will be the primary sources for procedural requirements for all the TDLR programs. The request today is for your approval of the adoption effective February 15th, 2016. If you have any questions, I'll be glad to answer those.
Commissioners, any questions? I'll entertain a motion to approve the rules as presented.
So moved. Second.
Second by, motion and second, all in favor say aye.
Aye.
Any opposed? Okay, moving to item L, discussion and possible action on the proposed amendments to existing rules at 16 Texas Administrative Code, Chapter 65, Subchapter A, 65.2, Subchapter C, 65.13, Subchapter I, 65.62, Subchapter J, 65.72, Subchapter N, 65.203, and 65.210, Subchapter O, 65.300, Subchapter P, 65.401, Subchapter R, 65.605, and 608 through 613, 65.613, and proposes new rules, Subchapter B, 65.6, 65.7, and 65.8, and Subchapter K, 65.86, and proposes the repeal of Subchapter B, 65.10, and 65.11 to primarily implement changes made by House Bill 3091 regarding the boilers program.
Mr. Chairman, for the record, Charles Johnson, Assistant General Counsel. You have in front of you a proposal to amend certain sections of Chapter 65 related to the boiler program. And as the Chairman indicated, these changes are being driven by amendments that were adopted and passed under House Bill 3091. While your proposed rule has about 15 proposed amendments, those amendments essentially go to clarifying existing language, and only one amendment goes to the actual House Bill 3091. And that amendment relates to a process to allow an entity to become an authorized inspection agency. And if you are aware, the existing statute, the statute prior to this last session had no mechanism for us as an agency to recognize an entity who wanted to engage or start acting as an authorized inspection agency. The way it worked prior to the statutory change was that the national board kind of authorized or approved an entity to become an inspection agency. The problem with that was that one of the requirements was that they be recognized by a state, and we had no mechanism to do that. And so the statute was changed to authorize the agency to adopt rules or standards for an entity to become an authorized inspection agency. And so the advisory board worked through the standards. The rule was published. We received no comment, and I think that's a tribute to the work that the advisory board did to propose this initial rule. And so we're asking you to adopt the standards as recommended by the advisory board with an effective date of February 15, 2016. And I'd be happy to answer any questions you may have about the proposed rule packet.
Commissioners, any questions? I'll entertain a motion.
So move as
So moved,
recommended.
yes.
So move as recommended.
Thank you.
A motion and a second.
And if I may clarify, you may have noticed I'm standing in the back of the room. It's because of my back. Not that I'm just bored with the presentation. And so if you see me stand, it's because of that and not because I'm not paying attention. So thank you.
Thank you, Charles.
What's the matter with your back, Charles?
Hip hop.
That's a different area, sir.
I like that.
Okay, moving down to M now.
Madam
Discussion
Chair,
of
did
possible
we-
action on the proposed
Madam
amendments.
Chair?
Did we
yes,
actually
sir.
vote on
Oh,
was there an
oh,
actual vote on that? I didn't hear.
Did we have a
We
vote on
need
that? I'm
to?
sorry, did we?
What?
Oh,
Yeah, well, I did, yeah.
Uproarious laughter.
Okay,
There was,
just
think
in
we had a
case for
motion.
formality, we had a motion and a second. All
yeah,
in favor,
yeah.
say aye.
Aye.
Aye, any opposed?
Second.
I don't think Fred's standing. I think he's sitting
Huh?
on a throne. I don't think Fred's standing. I think he's sitting on a throne.
Charles, yeah.
I mean, Charles, yeah. Charles, looks like you're more sitting on a throne.
King Charles.
Okay, discussion and possible action on the proposed amendments to existing rules in 16 Texas Administrative Code, Chapter 67, 67.20, 6725, 6730, 6765, and 6780. Proposes new rules 6721, 6770, 6771, and 6772. Proposed repeal of current 6770 to implement changes made by House Bill 2481 and to make editorial corrections regarding the auctioneer's program. Della.
Good morning, Commissioners. Della Lindquist, Deputy General Counsel. In this 84th session, House Bill 2481 essentially brought the auctioneer program to where it was almost a couple years ago when we lost the associate auctioneer program, and then the internet auctions became a topic, and then also a lot of different types of workers in an auction company would need a license. So this bill kind of struck through a lot of that stuff and essentially brought the auctioneer threshold. You need a license if you do live bid calling. And it brought the associate auctioneer, by popular demand, back into regulation. So we now will be issuing the licenses for the associates. One thing that was kind of left on the table that didn't change a whole lot is that the definition of an auction is now includes any forum or format. So that would include some internet auctions. That didn't change. So one of the things that we were required to do, we felt in this rulemaking, was to define the parameters for an internet auction that we would have some regulatory authority over. And we will get to that when we go through the rules. So the primary changes were bringing back the associate auctioneers. We now have some regulation over some types of internet auctions. And also, it carved some more exemptions for persons who have dealer licenses, so that you don't have to have a Texas auctioneer license to conduct some kinds of motor vehicle sales or auctions. Those were the three primary changes that this bill made. A lot of it was just technical. We brought back a lot of the associate auctioneer provisions that were there before, when we had it before 2013. And then we cleaned up and clarified some of the auctioneer requirements in 6770 and kind of divided it into sections: at the auction, advertising, and then after the auction. I'll go over, unless you have specific questions, I just wanted to kind of reiterate in 6730 how we wrote the rule with the guidance of the board. The type of internet auction that we would have some kind of regulatory authority over would be, the only kind we would not is if there's a live bid and if the property is solely able to be bid on through the internet. It's maybe not that common of a situation where there's a live bid and no one else is there within the parameter of, seeing the auctioneer to bid on it. But if there's a live bid over the internet and there's any people that have the ability to live bid on it, even though some people might be out bidding on it through the internet, we would consider that to be a regulated auction and would need a licensed auctioneer to conduct that sale, because it seemed arbitrary to have a live bid caller, and just because you happen to bid on it from outside or through the internet, then the auctioneer wouldn't have to comply with certain things, that he would have to comply with in the law. So the way we wrote the exemption was in 6730, an auction of property by live bid call, if the property is solely bid upon through the internet, is not subject to this chapter or the Texas Occupations Code and is exempt under 1802-0024, because the new bill did put an exemption in there for auctions conducted over the internet. So we felt like we needed to define what we thought that exemption should be. And it wouldn't be every single instance in which property could be bid on through the internet.
But if it's a bidded on where they're live bids and they're internet bidding, then they have to be licensed?
Yes.
If
Yes.
they're- Yes.
Yes.
Okay.
It was a little...
Really kind of...
It expanded it a little bit, but it was for the consumer protection to say, well, just because you bid on it through the internet and you bid on it live, you get all the protections of a licensed auctioneer and you don't. So we had to draw the line somewhere. So.
But I know there's some charity groups that they have these live bids and as part of their fundraiser and an activity.
That's an exemption. If it's
Is
a
that an
nonprofit, then they don't have to have a licensed auctioneer conducting those.
Okay.
They sometimes do. A lot of times they do.
Right. Sometimes they do. Right.
There's a long list of exemptions now, even longer
Okay.
after this bill. But some livestock auctions and now some motor vehicle auctions if the auctioneer has a certain kind of license, a GDN license or motor vehicle license.
And Mr. Moses, a lot of times on those charity auctions, they will have an auctioneer who is donating their time.
That's right.
To
Wow.
perform that auction, and they're the ones who are better equipped to get the most money, so you really do want to have a licensed auctioneer.
Yeah.
To generate that type of interest and excitement.
Okay.
To make people come out of their pocket.
So I'm happy to answer any further questions and would request that you move to,
So what is also on there as well, what about, I guess when we have a thing called, right now it's very popular, these reverse auctions, where they have, and these are normally done by private companies. I guess an auctioneer wouldn't.
A reverse
that would be-
auction?
Yes.
They're not included, probably.
I don't know what that is.
Reverse auctions where you.
Like Qbid and.
Yeah, where you.
Yeah.
Yeah, the
that's-
companies have they
You mean like an
propose-
eBay type
yeah.
thing?
Yeah.
Well, and that's interesting. We also have a rule in there that would exempt just a platform. We would consider, if you look at 67.30 new C.
See?
It's right under the definition of the internet and then blah, there's C. This chapter does not apply to a person providing an online platform to facilitate an
Okay,
auction.
okay.
So that would be sort of the Times,
That would, yeah, okay.
eBays, and a lot of that like that where it's not,
Okay.
there's really not conducting the auction so much. It's just, here it
The
is.
process.
We've got a seller and a
Yeah, that's
buyer.
right.
Here's the process.
That's the process, okay, all right. Okay.
Okay, and that was effective February 15th?
Yes, it would be effective if you adopted this rule proposal with an effective date of February 15th, 2016.
So move as recommended.
Motion, or second?
Second.
All in favor, say aye.
Aye.
Any opposed? Okay. Move to item N, a discussion of possible action on proposed amendments to existing rules at 16 Texas Administrative Code, Chapter 74, 7410, 7450, 7455, 7469, 7474, 7480. Proposed new rule 74105 to implement changes made by House Bill 3741 and make editorial corrections regarding the elevators, escalators, and related equipment program.
Mr. Chairman, for the
Charles.
record, again, this is Charles Johnson, Assistant General Counsel. You have in front of you a proposal to implement House Bill 3741. There are essentially 7 amendments being proposed, but only one relate to the implementation of the bill. And that provision specifically is in a new 75.105. The advisory board considered the comments that were, a comment that was submitted during the commenting period. While there was only one comment filed, it was a comprehensive set of comments that kind of went through each of the sections of the rules. And so you'll see amendments here where we've agreed with the commenter and made changes to the language that does not change the substance. The amendments were made in order to shore up or to sync the language in the rule to the language in the code. And so most of the changes you see here, the strike-throughs, are in response to making the language consistent with what's in the code. The one section that was a part of the implementation and received comment was on the actual 74.105, and that comment during the advisory board meeting was withdrawn. And so what you have in front of you is an agreed set of rules that was voted upon by the advisory board with a recommendation that you adopt them. And so we're asking, consistent with the advisory board's recommendation, that you adopt the rules with the standards for taking elevators out of service. If you, by quick summary, what we're dealing with here are situations where prior to the statutory change, there was no mechanism for a building owner to take an elevator or a piece of equipment out of service because the statute said you either you had to have it inspected or not. And if you didn't have it inspected, then you were in violation. And so we had a set of building owners who actually, the buildings may have been abandoned. There was a whole host of reasons that could exist where it was not economical or feasible to bring the elevator into repair, but there was no mechanism for taking it out of service. And so these set of rules provide a mechanism now for a building owner to actually take the equipment out of service without trying to find there was a mechanism prior to the statute, but it required them to do a whole procedural, pretty much destruction of the elevator, cutting cables and the whole 9 yards, which would take it out of service. This process is something short of that. The existing process essentially was for elevators that were going to be decommissioned. And so there's a set of elevators that are not being decommissioned but are not in service. These rules address those elevators. And so it provides a shorthand mechanism for a building owner to take the equipment out of service and not incur penalties for not having the equipment inspected. And so that was the intent of the statutory change, and that's what we're attempting to implement by the adoption of these rules. And so we're asking you to adopt the advisory board's recommendations with an effective date of February 15th of 2016.
Okay, do I hear a motion?
So moved.
Second.
Second.
All in favor, say aye.
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 Thank you,
Opposed? Thank you so much. Moving right along, staff reports.
Madam Chair, Brian Francis, Deputy Executive Director. The first thing I'd like to report on is that our fearless leader, literally showing his fearlessness today, is on a panel for the Texas Public Policy Foundation. It's the first time that we've had the opportunity to be invited to speak to the group. It's dealing with the criminalization of occupations and employment issues. So Bill is right there talking about our agency and its track record of using our penalty matrices, using our criminal conviction guidelines, using the advisory boards to vet and make sure that the work that you guys are doing today in determining should this person get a license or not, that our system looks at it on a case-by-case basis. That's not the truth for every other agency. So Bill is sitting right there in the crucible right now. So I'm excited about it. I can't wait to hear how his presentation went. There were a couple things that he wanted me to do today, Madam Chair, if you'll allow me the liberty of standing up a little bit. I want to do a couple of recognitions. One of the things that Bill really embraced last year is growing leaders and becoming a teaching leader. He really invested a lot of time in himself, but also in the agency and really giving our employees opportunities and training them up to really help our agency become more successful. To that end, we have a few recognitions. Randy Nesbitt is the third person in our agency to complete the Transformative Leadership Program. He transformed, he shrunk about 2 inches, and his brain grew about 20 feet. This Transformative Leadership Program is a relationship between Adelaide, Australia, and Texas, and it has been phenomenal, and he has already come back full speed with a lot of great ideas and energy, so we just wanted to recognize Randy for his completion of that program. And Commissioners, at the end of the meeting, I'd also like each of the folks to take a picture with you guys as a briefing. The next recognition we have, and this one we were worried about because we weren't sure if he was actually going to be able to complete it, but he did. He actually hung in there. No, I've got to give Ray a hard time. The Governor's Executive Development Program has been the cornerstone for the leadership here at TWR. We have sent, Ray is the 12th person that we've sent through this program. It's a 3-week intensive course where you are meeting other executives from the Department of Criminal Justice, from the State Office of Administrative Hearings. I went in 2001. That class, we experienced 9/11 during one of our sessions. I am still in contact with probably about 15 of my class members from 2001. It's an important program. Joyce Sparks and Barry Bells did a fantastic job. Ray knew a lot of this going into it, came back refined, but I'm excited and I'm really anxious to see what he brings back to the agency, what he learned. So I'll bring up Ray Pizarro. He's been wearing all of his wintry clothes. I thought he was going to have a scarf on the other day. I was like, that's going too far. Absolutely too far. Try again. Thank you for that. And Ray didn't say it, neither did Randy. Both of those programs are run through University of Texas, but they're really fine programs despite being part of the LBJ School of Public Affairs at University of Texas. Really, really, really hurts me to say that. So, our IT people are usually in dark caves, They're hidden away. They don't get all the glamour shots and all those sort of things. TDLR in the last year and a half has made significant investments, whether it's in the OI, our Office of Innovation area with our black belts, but we've also made significant investments in our project management tools, not just talking about project management, but having experts that know it. The project management professional is an internationally recognized designation by the Project Management Institute. You have to have a bachelor's degree, you have to have 4,500 hours of leading projects, and another 45 hours of training just to sit for the examination. It's extremely rigorous, and we're super proud that we were able to, I'll have Kenny stand up. Kenny Wright came to our agency with the project management professional designation, but on our staff and on our watch, our newly hired Marg Sue Owen, come on up. She just achieved this I'm super proud. Now, when they told her you're going to have to go to the meeting, she's like, are they going to ask me questions? What do I need to do? I'm proud of you. Thank you, Marg.
Commissioners, do y'all have any questions for Sue?
Like, I just want to sit behind the scenes. Don't bring me up here, but thank you so much. We're extremely happy to have you on board. Another recognition I'd like to do, the Leadership Texas, super important program for us. And our very own Tamla Fletcher was accepted into the 2016 program, and she also received the $5,000 scholarship from the Executive Women in Texas Government to pursue that program. So we're very proud of Tam. Come on up here. As if she wasn't already equipped the bosses around now, she's going to have that label, so she's going to come back fired up for us. Great.
I'm a Leadership Texas grad. You'll love it. Yay. You'll have so much fun.
Outstanding. And then the final recognition I want to do is part of the learning organization that Bill has empowered and authorized the Office of Innovation to pursue to help us. Alric is leading that front. He's out there finding new folks and new ideas to figure out how can we continue to grow as an organization. Part of those efforts are bringing in interns. And so I want to introduce you guys to our newest intern. He happens to be a graduate of Texas State, the Bobcats there. He has an economic and international business degree. He's working on his master's in public administration. He currently works at his father's company, his family's company, I should say, in the insurance business, and he is excited about being part of an agency that has an OI, or Office of Innovation function. Come on up here, Christian. Christian, you're right. He knows the Bobcat hug shake. Welcome aboard, man.
We're going to have to cut it.
So commissioners, we had Christian, we wanted to see if he really wanted to hang out with us. So we basically had him set up on what amounted to a third of a desk. And he's been balancing halfway on that thing, but Christian, we just gave you the okay to get a full desk. So you're going to be a person now. You're going to be a whole person at the agency. And Chairman, that's all I have unless there are any questions.
Does anybody have any questions? Congratulations to everyone.
Thank you so much for your time.
Great success. Commissioners, I'm going to have to cut us short because we've got some flights to catch, and we're going to be losing a quorum here, including me. But I do believe we might have somebody from Human Resources to introduce. Is that correct? Do we have new employees here? Do we have any new?
The field operations folks were here earlier, that they've already
left. Oh,
yes,
okay. Okay.
Sure did.
But I do know we had quite a few new people on board,
Yes,
so I do want to welcome them, and we always have such a great group of employees, and so it's always nice to have.
We got excited when we saw that
welcome
one of the inspectors' name was Joe Carrasco, but it turned out it wasn't Joe King
Joe
Carrasco.
King Carrasco, yeah.
We got pretty excited about it, but it's not the same one.
So, and so at that time, I would like to, if there's anyone else that would like to make a report, I'd like to invite you to come up at this time. I know we had quite a lot of information to present, but as I said, we're getting kind of cut short on time.
Madam Chair, we
uh-huh.
don't need to do the advisory board report.
Okay.
And I believe that the chairman wanted to wait until the next meeting to do
Appointments.
advisory board appointments. So-
Okay, so, is there anyone else that would like to make a presentation this time? Okay, if not, we'll move on to the, I know Commissioner Yurko had a question.
I did.
Oh, yeah.
I think, and Catherine, both of us did, wanted to reopen.
Okay.
Correct?
Yes,
I
correct.
want to speak. Brett, we had talked, we would like to see if we could bring back up for discussion the issue with the cosmetology. It was the one where we got the exception where they can do hair and makeup styling, but only at the shop or at the event, and we wanted to revisit that.
Okay, so at the February 9th meeting, have an agenda item that expands on that and have staff
Correct.
do some research in between?
Right,
Okay.
to see what we could do to, because I just don't think there are, I think there are a lot of people in the state of Texas that find that necessary to do for certain events, and they're law-abiding citizens that I think this little glitch makes them look like they're committing something that's wrong that shouldn't be made wrong.
Okay. We will be prepared.
Okay, do we need a motion to put that on the agenda? Does that need to be a motion or anything? or is
No,
it
ma'am.
Not
okay to-
necessarily.
Okay, okay. And at this time, let's move to item number R, public comment. Is there anybody here that would like to make a public comment at this time? I don't have any. If not, let's see, moving to item, what is it,
Yes,
S?
right.
Discussion of date, time, and location of future meetings. I know we just said
We've already
February
got that
9th,
established.
and did we have any other meetings scheduled? March? March the 9th? February 10th and March 9th? Okay. February 10th and March the 9th. So everybody mark your calendars, February 10th, March 9th. And there's no further items to discuss. We'll move to item L, or T, adjournment. Thank you for coming.
Madam Chair, you did a fantastic job. Thank you.
Thank you.
We're gonna crowd you real quick,
Commissioners,
take
if you got a
pictures.
minute, let's
If I can get everybody